Hi guys, welcome to our webinar. The webinar is on the Fire Safety Bill stroke Fire Safety Act. Originally when we wrote this presentation it was still the Fire Safety Bill, however it has recently it's recently received royal assent and is now the Fire Safety Act. Today's agenda, we are going to be looking at the reason for and the overview of the Fire Safety Act 2021, what it means for the responsible person, including potential fees and charges, the provision of information for the fire and rescue service, including premises information boxes. We are going to talk about the potential for personal emergency evacuation plans, often abbreviated as PEEPs, for residents of high-rise residential buildings. And we're going to talk about the provision of information for residents, and we are going to have a look at another salient point in the Fire Safety Act, which is fire doors and the compartmentation. Excuse me. Moving on, we will, if we have time at the end, we will have a look at the Building Safety Bill and what we can potentially expect, because both are going to run hand in hand. One thing I would like to point out at this moment in time, it's worth noting that the situation with what we believe are anticipated requirements remains very fluid, with different opinions on what to expect in the actual legislation and regulations. So whilst the following is based on our understanding of what is likely to be included, but some issues such as personal emergency evacuation plans or inspection frequencies, etc., may be subject to change when the regulations are actually written. The Fire Safety Act and the reasons for the new Fire Safety Act. The new Act is an effort on behalf of the government to improve fire safety in multi-occupancy domestic premises following the tragedy at Grenfell Tower, which is almost 4 years ago now. The intention of the original Fire Safety Bill was to implement the recommendations made by Sir Martin Moore-Bick in his Phase 1 report arising out of the Grenfell Tower inquiry. The Fire Safety Act has finally been granted royal assent, so whilst the main parts of the Act will not come into force immediately, some will do over the coming weeks, starting from the 29th of June. As a summary, the Fire Safety Act amends the Fire Safety Order to require all responsible persons, i.e. the relevant duty holder under the legislation, and it's worth noting at this point that there may be more than one, to assess, manage and reduce the fire risks posed by the structure and external walls of the building for which they are responsible. And that will include any cladding, balconies and windows, and also individual apartment doors opening onto common parts of the building. It's worth noting that the Act applies to all multi-occupied residential buildings and is not dependent upon the height of the building. It also allows the Fire and Rescue Service to enforce against non-compliance in relation to the external walls and the individual doors opening onto the common parts of the premises. It's also worth noting that despite several proposed amendments by the House of Lords, it must be noted at this point that the Act does not address remediation costs in relation to cladding or its replacement. The intention of the Act is it will run alongside the Building Safety Act when that comes into force. That bill is yet to be laid before Parliament and is not expected to come into force until 2023. The new legislation will enhance the existing regulatory regime for the building design and construction. Excuse me. And that will focus on high-rise residential premises. A new building safety regulator sitting within the Health and Safety Executive is already appointed to oversee the design, construction and occupation of new high-rise buildings. Alignment between the two regulatory regimes will be important. While the Building Safety Act does not have the same focus on the operational response to fire, there's likely to be some overlap between the two regulatory regimes once the Building Safety Act is in force. More details are awaited, but there is likely to be a duty of cooperation between the duty holders under both regimes. and that's in order to ensure that the building as a whole is effectively managed. So the Fire Safety Act is clarifying the scope of the Regulatory Reform Fire Safety Order, often referred to as the FSO, in that for any building containing 2 or more sets of domestic premises, the main significant points of clarification currently revolve around the following. The external warning system, including attachments such as any balconies, and the apartment or flat entrance doors within the communal areas. Both should be included in the fire risk assessment of any relevant building, and the time to review your fire risk assessments on any relevant building is really now. An amendment is also issued that statutory guidance under Article 50 of the Fire Safety Order will be issued to assist responsible persons, e.g. property managers, etc., who this seminar is aimed at, the enforcing authorities themselves, such as local authorities and the local fire services in your areas, and also fire risk assessors like ourselves, who are deemed competent persons under the Act. It was also evident with the Fire Safety Order, when it was implemented in 2005, that there were some anomalies between the order and its practical application when it came to purpose-built apartment blocks. So in 2011, the Ministry for Housing and Local Government issued a specific guidance document relating to apartment blocks. But even then, external warning systems were generally presumed to be acceptable if they'd passed building control requirements, e.g. Regulation B4. Recently, the Local Government Association stopped hosting the document. However, in the last couple of days, and this is what I mean about the situation being very fluid, the document's recently been reviewed with a revised version available on the government website, with some further revisions to paragraphs 79.9 and 79.11 due later this year. They are currently greyed out in the document. Now, the reason for the revision is due to potential legal action being taken by the family of a disabled resident who died in the Grenfell tragedy. So, at the moment, other guidance for consideration would include Her Majesty's Government sleeping accommodation, fire risk assessment guidance, the Ministry of Housing's consolidated advice note for building owners of multi-storey and multi-occupied residential buildings that was dated January 2020, specifically in relation to cladding issues, and also where your building may have cladding issues or there may be a requirement to consider changing evacuation strategy, the National Fire Chief Council's simultaneous evacuation guidance. And if you notice, I put in there temporary. This is because the purpose of simultaneous evacuation and then purpose was intended to be temporary until the remediation works could restore the premises to support a stay put policy. So the Fire Safety Order improving compliance for PMs, or responsible persons. Now, it should be noted that some of the following could be revised once the definitive legislation is published. So the ones we want to look at today are the ones that I've highlighted in red. So we're going to have a look at what it means for the responsible person, what it means with the provision of information, and fees and charges, etc. So new responsibilities for the responsible person. There are new requirements for all responsible persons to identify themselves to all other relevant parties. And that includes accountable persons and building safety managers, e.g. where they share or have duties in respect of the same premises. The Fire Safety Act will place additional duties on responsible persons. So in short, what must be considered as part of a fire risk assessment will be significantly extended, as well as the potential need for additional safety measures and remedial action to ensure compliance with the law. For external warning systems to assist responsible persons, there is a new PAS guidance document, which is PAS 9980, and that is in relation to fire risk appraisal and assessment of external wall construction and cladding of existing blocks of flats. So it's an approved code of practice by the British Standards Institute. Therefore, once it's finalised and published, I would think it's imperative that responsible persons familiarise themselves with the government's risk-based guidance document so that they fully understand what's required of them. And only then will they be able to properly assess what actions are needed in relation to external warning systems, so that if they're ever questioned by the fire service, they can demonstrate compliance with the law. And that might mean in practice, that will definitely mean in practice having further intrusive surveys done by competent persons. So what are the legal implications for the responsible person? Any responsible person who fails to follow guidance will inevitably face the very real prospect of enforcement action, which in the worst case scenario could include a criminal prosecution and also the prospect of an unlimited fine, depending on which court structure it takes place in. What are the legal implications for organisations? The government have also removed the provisions under the Fire Rescue Service Act 2004, which used to prohibit the Fire and Rescue Service from charging for actions taken in their capacity as the enforcing authority under the Fire Safety Order. Now, to align where relevant with the Draft Building Safety Bill, but also in relation to all action taken as a capacity of the enforcing authority, they now have the capacity to charge. Now, as yet, no fees have been set. However, it's reasonably foreseeable that if we look at this across the board, then if this has been brought in line with what will happen under the Building Safety Act, which has been enforced by the HSE, the HSE's fee for interventions currently stand at £160 an hour. But it's worth noting that you will not pay that if you are compliant with the law. Moving on, we'll have a look now from practical application for property managers. So we're going to have a look at the definition of a high-rise residential building. We'll talk more in detail about the information for fire and rescue service, premises information boxes, information for residents, evacuation plans. We'll touch on personal evacuation plans should they be needed, and we'll talk about fire doors. So the definition of a height for high-rise residential building, excuse me, common terms used to categorise 12 buildings include a medium-rise building, and that is a building between 11 and 18 metres to the highest occupied floor, or often in some areas referred to as 4 stories or more. For a high-rise building, these are buildings that are referred to as being over 18 metres to the highest occupied floor, and again in some areas that is simplified to 6 stories or more. For super tall buildings, that includes any building over 300 metres in height. So how to measure your premises in accordance with approved document B 2019. The measurement is taken from the height of the top story, from the upper floor surface to the top floor at ground level of the lower side of the building. That's a slight change. Most fire services in our area in the northeast used to take that from where they entered the premises. So depending on how the land lies, and bear in mind you may have a sloping site, that you now take it from the height of the top story to the low side of the building. So what kind of information does a property manager or responsible person need to provide for the fire and rescue service? Well, the duty of the owner of the premises or the property manager or the responsible person, they have a duty to share information with their local fire and rescue service in respect of each building for which an owner or manager is responsible. And that should include the design of its external walls and the details of the materials of which those external walls are constructed. In respect of any building for which an owner or manager is responsible, which contains separate flats, they should undertake inspections of individual flat entrance doors. That is currently anticipated to be annual inspections. We'll look at that in more detail later, because the actual reference in Sir Martin Moore Bick's recommendations has a specific caveat in that I want to discuss with you later. So also in respect of any building for which an owner or manager is responsible which contains separate flats, they should undertake monthly inspections of lifts and report the results to their local fire and rescue service if the results include a fault. And they should share evacuation and fire safety instructions with residents of the building. So relatively common sense kind of stuff. Let's have a look a little bit more closely with information for residents. So the owner and manager of every residential building containing separate dwellings, whether or not it's high-rise, will be required by law to provide fire safety instructions, including instructions for evacuation. And they should be in a form that the occupants of the building can reasonably be expected to understand, taking into account the nature of the building and their knowledge of the occupants. There is a requirement for residents of multi-occupied residential buildings should be provided with information and instructions including the risks that may be identified by a fire risk assessment, the preventative and protective measures in place to mitigate potential fire risks, and the role and responsibilities of relevant responsible persons, including your name, capacity, and your contact details. Now that information can be provided in premises information boxes. So we would advise that premises information boxes are considered to be installed from this point forward, because I think it's reasonably foreseeable that this is one requirement that is definitely going to be in the legislation. So a requirement for premises information box, it should be positioned in an appropriate location at the premises, usually where the fire service, you'd expect the fire service to enter that premises. It should be clearly identifiable to the fire and rescue service. It should also be readily accessible to the fire and rescue service. So that may mean having some kind of coded lock system or break glass for a key, etc. It should also be of sufficient size and dimensions to contain things like plans and relevant information, and where possible secure from unauthorised access and casual vandalism. So what kind of information would we include? Basically anything that we consider relevant to the fire and rescue service in their capacity to basically deal with an emergency situation. So that would include contact details for the relevant responsible person or persons, floor plans of the building, often referred to as zone plans, etc. If there's a fire alarm system installed. Definitely the location of any isolation points for power supplies such as gas, electricity, also sprinkler, also location of sprinkler isolation points, etc. The position of any override switches for fire alarm systems or smoke vents. It's thought at the moment it need to contain a copy of the fire risk assessment, and it's definitely stressed that all information should be presented in a clear and readily understandable format, and that all information should be reviewed on a regular basis and kept up to date. However, I'm of the opinion that the bottom one, that all information should be reviewed on a regular basis and kept up to date, is not without foreseeable issues for property managers or responsible persons. Now, what do I mean by that? Here's some things that I see as potential difficulties. It begs the question, is your purpose-built apartment block being occupied the way you think it is? Here's a typical example of an apartment offered for, well, as you can see, it's offered on hotel sites. So for all the apartment block was built as a purpose-built apartment block, the owners now are basically advertising it for, through sites, as you can see, such as TripAdvisor, hotels.com, Bed and Breakfast UK, things like that. So it begs a question, and this raises issues in relation to, you know, the evacuation strategy. You know, how many hotels, we asked the question, how many hotels would operate on a stay put policy? It also begs the question is how are people who are staying in these rooms, how are they informed of the evacuation strategy? If there is a fire alarm system, you know, it's highly unlikely that it will support an immediate evacuation strategy unless it is an L1 system, which is highly unlikely in a purpose-built apartment block. Probably the best you're going to get is probably L4 to cover the communal escape routes, etc. Now, Chapter 33, the Grenfell Inquiry, the recommendations. One of the recommendations in the inquiry was that personal emergency evacuation plans, or otherwise shortened to PEEPs, were undertaken by the responsible person to assist anybody with a prescribed characteristic or a disability, to assist them to escape the premises, which in theory sounds perfect. But as we've just witnessed with that previous advertisement, it's not without issues. And 33.22 recommends that the owner and manager of every high-rise residential building be required by law to prepare personal emergency evacuation plans for all residents whose ability to self-evacuate may be compromised. 33.22F recommends that the owner and manager of every high-rise residential building be required by law to include up-to-date information about persons that require assistance and their PEEPs in the premises information box. Talking to representatives of the local fire service in our area, their attitude at the moment is keep that information very, very basic. And what we mean by that is basically just Mrs. Jones, wheelchair user, apartment 77, etc. Because in an emergency event, quite often the fire rescue service haven't got time to read through a full personal emergency evacuation plan as you'd expect one to be written. So what is reasonable? So for responsible persons in high-rise residential buildings to provide relevant details of residents who self-identify as requiring assistance to evacuate. Once they've self-identified as requiring assistance to evacuate, at that point it would be what's the phrase? Hang on, I need to pause that. In relation to personal emergency evacuation plans, what could be considered reasonable? So for responsible persons in high-rise residential buildings to provide relevant details of residents who would self-identify as requiring assistance to evacuate, it would then be appropriate to, in my opinion, to undertake a risk assessment on that basis and ensure that the information is kept up to date and is placed in the premises information box. As noted previously, the fire service in our local area are keen for that information to be just proportionate to the risk. They haven't got time to basically deal with reams and reams of paper when they're in an emergency event. So one thing you have to also consider is for certain premises that if it's identified that a PEEP is required, particularly for a building that may already have a wait and watch, that you staff that building so the people who are providing the wait and watch for you are aware and are there to assist those with that need a personal emergency evacuation plan. So who may need to be included in a PEEP? Well, people who have, obvious one would be a mobility impairment, somebody wheelchair users, etc., or somebody who has difficulty walking, but it could also be somebody who has a sight impairment or a hearing impairment or a cognitive impairment. There could also be something as basic as a medical condition or injury which may cause them to need assistance to evacuate safely. Now that could be permanent or temporary. There could be something as basic as a broken leg or a lady in the late stages of pregnancy. Each person's disability needs are different, and therefore each person requiring a plan needs one specific to their own requirements. However, it's also important to note that not all people with a disability will require assistance from another person. In most instances, they manage quite capably with normal life. So where suitable aids or reasonable adaptations have been provided, the person will often be able to facilitate their own escape, e.g. they'll be able to self-rescue. So more importantly, recognising an individual's dignity and their right to independent evacuation as part of the planning. So good negotiation skills are needed. But one thing of note, if you do have to provide a PEEP, is that the PEEP must not rely on the Fire and Rescue Services intervention to make the plan work. So if you're in charge of a premises where you may need to consider staffing that premises accordingly, particularly in areas such as assisted living and things like that, which are obviously slightly different to some of the premises that we're discussing at the moment. But it's just worth noting that the PEEP must not rely on the Fire and Rescue Services intervention. Right, I want to touch now on the importance of fire doors. As a fire risk assessor, this is a common issue that occurs regularly on fire risk assessments that we conduct up here in the northeast. So I want to pose the question to tie in with the slide: how significant do you think this photo is in relation to life safety? As you can see, we've got a fire door there, and we have smoke breaching it. What you have to consider is that smoke travels at between 15 and 90 metres per minute, depending upon its conditions. Which means on average, in about 5 minutes, a domestic premises will be engulfed. So you have to consider things like, could the residents be asleep? Could the fire be well established before the remaining residents realise there's an issue? Is there a method of extracting or venting the smoke? And more critically, does it work? Recent events in certain fires have raised that issue, that if the smoke, the outcome might have been significantly different had the smoke ventilation been working. So in my opinion, for all that bit of smoke coming through the door may appear to some to be relatively meaningless, in my opinion it's potentially catastrophic. Now, like I said previously, as part of the Grenfell inquiry in section 33 were Sir Martin Moore-Bick's recommendations. In 33.29b, he talks about communal compartment doors. So the owner and manager of every residential building containing separate dwellings, whether or not they are high-rise buildings, are required by law to carry out checks, and he said at the time, of not less than 3 monthly intervals to ensure that all fire doors are fitted with effective self-closing devices and in working order. Now, whether that 3 monthly becomes proportionate to, depending on the size of the premises, I'm not particularly sure. But what we are confident of is checks must include the following: that the door leaf itself is in good condition and is free from any structural damage, that the door is parallel in its frame with a reasonable 3mm gap, and this is really important to ensure that any cold smoke seals are able to prevent smoke ingress into the escape routes, etc. That the self-closing devices are fully functional, are in good working order, and are in a good state of repair. That the hinges are the correct grade and are in good condition to ensure that the structural stability of the door, and particularly that all intumescent strips, cold smoke seals, etc. are in good condition and are free from damage, and that are continuous as far as possible. Obviously around locks and that, they are not continuous, but for the remainder of the door as continuous as far as possible. It's just worth noting at this point that one of the common issues for property managers that we represent is fire door remediation works by contractors. And I would just like to stress at this point that near enough is not good enough. The gap around the door is 3mm for a reason. And a quick analogy is that you wouldn't accept a car salesman telling you that the brakes on a new car might stop you at 70 miles an hour. So why accept a contractor telling you that a poorly adjusted fire door might prevent smoke ingress? What I would advise, if it's going to become part of your duties, etc., is one, that you do an appropriate sort of training course on this. You know, there's diplomas in fire door inspection now. It's worth noting at that point that does not make you that would not get you on a national register for fire door inspections. You would have to do a further course, but it may be a good starting point to boost your confidence in inspecting fire doors. And what we've included there on this slide is just a typical table, typical checklist with a door reference number, what the required fire rating should be in the approved document, and that's an important note, because if the compartmentation is intended to be 60-minute and you've only got a 30-minute door, then you've got an issue straight away. What the existing fire rating of the door is, so does that basically match up with the requirements of the building regulations. Now there you notice I've got door type, single door, the date of the survey, the door leaf's in good condition, the door frame's in good condition. However, at the time of the inspection, the incandescent strips and cold smoke seals have failed. Then they fail because the clearance gap is greater than 3mm. The hinges are okay. We've got 3 number British standard hinges. It's a flat door, so it doesn't need a fire door keep shut or a fire door keep locked sign on it. It has a self-closing device, a concealed device, often referred to as a pergo, which is a concealed chain within the rebate of the frame. It doesn't have any air transfer grills in. It did have a vision panel, which was British standard Pyrogard glazing, so that was considered a pass. So in the comments, we've made comments that the door is missing cold smoke seals to the frame and a gap at the top of the door exceeds 3mm. So the remedial action will be to replace the cold smoke seals to the door frame and adjust the door to ensure the gaps do not exceed 3mm. So that's just a typical checklist. You're quite within your rights to form your own. Or if you're not that confident, then I would recommend that you probably look at somebody who's on a national register as a competent fire door inspector. Now I just want to have a touch on one of the requirements of 33.3 of the Grenfell inquiry, which was in relation to apartment or flat entrance doors. Now I've put there significant changes, but to be perfectly frank, we have been, where possible, sampling flat entrance doors for a number of years now on the basis that they form the overall compartmentation of the escape route. But Sir Martin Moorbick was quick to point out that I recommend that all those who are in whatever capacity for the condition of the entrance doors to individual flats and high-rise residential buildings, but this is the caveat that he put in, whose external walls contain unsafe cladding, be required by a law to ensure that such doors comply with current standards. So there is that little caveat that people are picking up on, saying, well, it's only in relation to buildings that have unsafe cladding, etc. But my attitude to that is the entrance door forms part of the overall compartmentation of the escape route, or the individual compartment if it's retained behind another compartment door. So in my opinion, they need inspecting. A few slides now just to show you typical examples of what we encounter doing fire risk assessments. As you can see from that one, we have a door with a cracked Georgian wired side panel so therefore the integrity of the glass can't be proved. We have a door there that has the bottom vision panel has been either kicked through or damaged at some stage, and we have a small plywood panel replacing that. Again, side panel's been removed, and the glass has become damaged or vandalised, and what they've done is just took a basic bit of chipboard in there and painted it. And finally, again, the side panel with a bit OSB boarding instead of the glazing. Now, you don't need to be on the inside of the flat to basically confirm that them doors are not suitable and will not form reasonable compartmentation of the escape route. It's reasonably foreseeable that all them doors, should a fire break out on the other side of them, will leach smoke or potentially flame into the escape routes very, very quickly. Now, when it comes to the inspection of fire doors, that's obviously going to need additional planning on behalf of the property managers or responsible person to ensure the doors are available for inspection. So it is going to need further coordination. What I just want to touch on now is moving forward with fire safety on new high-rise developments. And what we're talking about now is the Building Safety Bill. So what can we potentially expect? There will be a new regulator known as the Building Safety Regulator, and this has already been set up by the Health and Safety Executive. So the initial scope of the new regime will be multi-occupied residential premises in excess of 18 metres of height or greater than 6 stories. One of the significant issues is that the applicants or the developers will not be able to choose their building control body. It will be chosen for them. Either local building control or an approved inspector will be assigned to them. There will be a mandatory occurrence reporting system for any safety failings, and Dame Judith Hackett's recommendation on the golden thread of information will be key. So what can we potentially expect? So a high-risk premises will need to be registered by an accountable person or the accountable person prior to its occupation. The premise will be placed on a register and the register will be published. The accountable person must apply for a building insurance certificate and that must be displayed. The application must be accompanied by the latest safety case report and any other prescribed documents. So the accountable person must appoint a building safety manager, and the accountable person must assess the building safety risks to prevent a major incident such as grenfell, etc. happening in the future. In addition to that, although the new regime is not expected to come into force until 2023, it's worth noting that the government have announced that Gateway 1 will be introduced from the 1st of August 2021, and that's by way of amending the Town and Country Planning Act in England. If you're working in one of the devolved countries such as Wales or Scotland, etc., it'll be worth checking the local planning acts in them particular areas. And what Gateway 1 relates to is obtaining planning permission for relevant buildings. So under the new rules, the HSA will become a statutory consultee on all relevant planning applications. So we'll have a quick look at the requirements of Gateway 1. So a fire statement will need to be submitted with an application to the HSA's regulator, and that statement will need to include information about the fire service access and water availability. They'll need to detail any fire strategy for the building. They'll have to have details to demonstrate whether the building has an external warning system which will need external sign-off by a fire engineer, etc. They'll need to include details of any fire suppression systems that may be installed, sprinklers, etc. And they'll need to include details of the engineered evacuation strategy, e.g. stay put, phased evacuation or immediate evacuation, etc. Now some people might be thinking, Gateway 1, why now? So the reason for the introduction of Gateway 1 ahead of the rest of the building safety regime is needed based upon the time it can take to get a development from the feasibility or the concept stage to final completion, and obviously resident occupation. So developers need to start considering this requirement now. However, it should be noted that the amendments proposed after the initial draft of the Building Safety Bill have still to be heard by Parliament and the House of Lords, etc. Which means anyone for another game of ping pong. Joking aside, hopefully the combination of the fire safety and building safety bills will significantly reduce latent building issues currently being experienced by property managers, responsible persons in the future. Thank you for attending, and if you have any questions, please provide your feedback via info@Carney-Consultancy, and particularly if you want any other topics covered in the future. And just to let you know, we are delivering a further webinar on the HSE Stress Toolkit on the 26th of July 2021, and we will also be delivering a webinar on apprentice grants, and we'll update you with a date once we've got that one confirmed.